Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. These episodes have been very long of late, no? I'll be better this week, I promise. But mostly because the circuits were better to me this week. I am, after all, their slave. With no big immigration news this week, at least on my feed, you know that a Patreon shout-out is coming. And we've got some new additions, such as Amanda Doom from Texas, Nicole Whitenauer, and Patrick Terrell. You all, along with everyone else who's been with the podcast for a long time, help me do what I do. I appreciate you so much. Maybe see you and everyone else out there in Podland at the fall immigration conferences. They're coming. And I hope to see you there so I can thank you in person. 5 cases this week. Lots of asylum type stuff, but not all. You'll see. Why do I even summarize? To the First Circuit! Our first case is Murillo Morocho v. Garland, published by the First Circuit on August 21st, 2023. This case is about Convention Against Torture Protection. And it's pretty timely, given the BIA's recent decision in the matter of JGR, which itself followed a remand from the First Circuit in a different case. This one's going back too. Mr. Murillo Morocho is from Ecuador, a country where I believe at least 2 presidential candidates were recently killed. He claims that he's the victim of political prosecution, attempted murder at that. That makes this a prosecution as persecution claim. He claims that he got into a fight with a man who is part of a powerful family in Ecuador. Mr. Murillo Morocho claims that he was attempting to stop a rape of his girlfriend. The alleged victim and the witnesses say, though, that Mr. Murillo Morocho was enraged because he believed that the man had lowered his girlfriend's shorts and then stabbed the alleged victim with a piece of glass multiple times. In immigration court proceedings, Mr. Murillo Morocho and his uncle testified that the man's family, this powerful family in Ecuador, had twice threatened to murder Mr. Murillo Morocho and his family. The uncle was threatened too and even obtained a stay-away order and relocated to another city. Mr. Murillo Morocho also claimed that this powerful family had interfered with his ability to defend himself in court in Ecuador. Mr. Murillo Morocho claims that he fled Ecuador for this reason. And I guess he came to the United States with that authorization because DHS charged him as such 3 years later. Doesn't look like he has a criminal record in the U.S., but also, it looks like that only Convention Against Torture Protection is at issue before the First Circuit, so that's what we're going to focus on here. A footnote in the decision indicates without saying it that the reason for that is probably based on an Interpol Red Notice, which the IJ probably relied upon to hold that there were serious reasons for believing that Mr. Murillo Morocho committed a serious non-political crime abroad, attempted murder, which, if true under the statute, would bar everything except cat deferral. That's me, not the decision, but I bet that's the case. And that's a heck of a procedural posture then for Mr. Murillo-Morocho to win in, right? But when he did at the First Circuit, after losing before the IJ and the BIA, even though ICE removed him to Ecuador during the pendency of this petition for review, so he is in Ecuador at the moment. But here we go. First, some law. Important for appeals of all types, because it implicates standards of review. In the First Circuit, whether a person is likely to suffer harm and the role the foreign government will play in that harm is a finding of fact. Bad standard of review before the circuit court. But, quote, whether the government's role renders the harm by or in the instigation of or with the consent or acquiescence of a public official, i.e., how the law applies to the facts, are legal ones, end quote. Good standard for review on that issue, de novo. The First Circuit determines that latter issue just by looking at the record as it existed before the BIA, without deferring to anyone. Before the First Circuit, it came down to two issues. One, was that influential, powerful family going to kill or torture Mr. Murillo-Morocho or find a way to make it happen? And or two, quote, the likelihood that Mr. Murillo-Morocho would be detained upon return to Ecuador in a prison system where gruesome, medieval-esque violence is running rampant, end quote. On those two issues, Mr. Murillo-Morocho's counsel, pro bono it seems, made four different arguments. Fortunately for Mr. Murillo-Morocho, but unfortunately for me, the First Circuit took each in turn. First, the First Circuit held that because the immigration judge held that the family was not more likely than not to try to torture Mr. Murillo-Morocho themselves, a factual finding, remember? The IJ didn't need to then determine whether the Ecuadorian government would consent or acquiesce to the torture. Makes sense, right? The IJ held that torture wasn't more likely than not to occur, so why go to the next element, said the First Circuit. But the IJ and the BIA weren't so correct on the fear of prison violence, or violence from that family if Mr. Murillo-Morocho was put in an Ecuadorian prison, said the First Circuit. On this point, the IJ needed to determine whether Ecuadorian government officials would consent or acquiesce to the torture feared in prison, because the IJ recognized that acts of violence are widespread in Ecuador's prisons. Therefore, quote, the IJ had to proceed and determine what steps the government likely would or would not take, and whether that action or inaction constituted consent or acquiescence, end quote. As to the prison violence, that is. To the First Circuit, actually, quote, the IJ did just that, end quote, and ruled against Mr. Murillo-Morocho. But it looks like that the First Circuit just doesn't think the analysis was nuanced enough. Because for cat protection, willful blindness by the government to private torture will cut it and satisfy the consent or acquiescence standard. And that's the case in most circuits. Generalized evidence that the government takes efforts, quote, no matter how minimal, end quote, to protect similarly situated individuals won't cut it to show that the government isn't willfully blind. Seems to be to the First Circuit what the IJ and the BIA relied upon here, discussing generally what Ecuador's president has been trying to do to stem prison violence. Mind you, and not in the record, but I do have some Ecuador cases, there have been multiple unsuccessful states of emergencies in recent years issued in Ecuador to try to stem the violence in Ecuador's prisons. With that in mind, the IJ and the BIA did not discuss how effective the efforts had been. And to me, if a president has to implement multiple states of emergencies on the same issue in a very short period of time, it wouldn't seem that the government is being very successful stemming the prison violence. The agency's failure to consider all this is all the more problematic where the First Circuit reads the record as showing that yes, quote, the government's steps have been inadequate and ineffectual, end quote. Determining why that is might be the important reason on remand. To the court, the focus on high-level action isn't really the correct one for cat protection purposes, as the First Circuit has explained of late, particularly where there is a possibility that, quote, lower-level government officials, such as prison guards, still may be acquiescing in torture by private actors, notwithstanding other officials' attempts to thwart such complicity, end quote. Restated, low-level guards cut it for cat. Even the BIA recognizes it. The First Circuit recognizes that it's Mr. Murillo-Morocho's burden, yes. But the court doesn't know whether the IJ and BIA really conducted the proper willful blindness analysis. So it had to remand for further consideration of the, quote, claim premised upon the rampant violence in prisons, end quote. Cat's back on the table. Now, Mr. Murillo Morocho is in Ecuador, remember, and the First Circuit affirmed quite a few factual findings, so it definitely might be difficult to win on remand in this already difficult case. But to quote Jim Carrey, you're telling me there's a chance, First Circuit. And congratulations Tasha J. Bahal and Wilmer Hale for petitioner. And that is Murillo Morocho v. Garland. Sticking with the First Circuit, we have Montoya-Lopez v. Garland, published by the First on August 21st, 2023. This case is about past persecution and particular social groups. Miss Montoya-Lopez is an asylum seeker from El Salvador. She came to the United States without authorization in 2016 and has 2 U.S. citizen children. Her parents and 3 of her 5 siblings still live in El Salvador. In that country, she worked at a fruit stand owned by her sister and earned about $10 a day. She worked 6 days a week, working between 13 and 16 hours per day for $10 a day. Seems like her sister might have owned this fruit stand, and when the fruit stand became more profitable, MS-13 arrived to extort money. They demanded $25 a week at threat of death. So Miss Montoya-Lopez and her sister paid. But it was always Miss Montoya-Lopez making the payments physically, as her sister rarely showed up to the stand. And over the course of a year, the demands rose all the way up to $75 a week, which the sisters just couldn't make. Just before she left El Salvador, Miss Montoya-Lopez told the gang that they couldn't pay anymore. The gang said they didn't care. Miss Montoya-Lopez fears that if she returns to El Salvador, MS-13 will hold her responsible. Also, quote, she believed that by leaving El Salvador rather than continuing to pay extortion, she put herself in danger from the gang, as she could recognize the gang members and identify them as extortioners to other people and the police, end quote. Her sister kept paying, though, it seems. By the time of the merits hearing in immigration court, Miss Montoya-Lopez hadn't spoken to her sister in over a year. She didn't know the status of her sister or the fruit stand. The IJ and the BIA denied the claim, believing that Miss Montoya-Lopez hadn't suffered past persecution, and that even if she had suffered sufficient harm, it wasn't on account of a viable particular social group. The First Circuit agreed. And to be honest, reading the many footnote observations from the court identifying what it believes to be unaddressed inconsistencies, and the fact that Miss Montoya-Lopez didn't submit corroborating witnesses or sign statements, it seems that the First Circuit just doesn't see a case here. In this case, no tribunal found cognizable the particular social groups of family members of a business owner perceived as wealthy, or people who have fled gangs instead of continuing to pay extortion. So you'll never be able to win an asylum or a withholding claim if the courts don't believe your particular social group cognizable, assuming, of course, it's a particular social group-based claim. Return to all that in a sec, because the First agreed that the harm just wasn't bad enough. Don't get me wrong. It has long been the case in the First Circuit that, quote, credible, specific threats can amount to persecution if they are severe enough, particularly if they are death threats, end quote. And the addition of physical violence, though not required, helps makes the showing. Here explained the First Circuit that threats were just too vague. They were of a general nature. Quote, there were no displays of force or violence to accompany the threats, and the petitioner was never physically harmed by the gang during her time in El Salvador, end quote. Nor does Miss Montoya-Lopez really know what happened to her sister after she left the country. Now, also don't get the court wrong, though, quote, extortion alone may constitute persecution, end quote. Very good to know. But, quote, to reach this level, the extortion must constitute deliberate imposition of severe economic disadvantage or the deprivation of liberty, food, housing, employment, or other essentials of life, end quote. So you've got a chance in these extortion cases, but it's a pretty high burden. Not met here. even though the $75 a month eventually extorted required that the family buy fruits on credit and totally wiped them out. Still, it wasn't of, quote, such difficulty as to deprive her of liberty, threaten her survival, or bar her from employment, end quote. But there's your standard. Past persecution is of course important because if shown, it flips the burden in removal proceedings to DHS to rebut the non-citizen's well-founded fear. That's why we're always arguing for past persecution. But here, said the First Circuit, the harm wasn't sufficient enough, and in any event, the asserted particular social groups were not actually particular social groups, explained the First Circuit. To be a particular social group, the purported group must be immutable, particular, and socially distinct. Those are the three requirements. Family members of business owners perceived as wealthy isn't immutable, explained the First Circuit. Even Miss Montoya-Lopez's sister, it seems, may have changed that status as a business owner. And if she changed her status, it might be difficult to show that the group is immutable, that is, something that the non-citizen cannot change. The group also isn't particular. Quote, a proposed social group such as the one petitioner proposes, that encompasses all family members of all business owners, past or present, who were perceived as wealthy at one point in time, fails to meet this standard because it represents a large, diffuse portion of society with characteristics simply too amorphous to readily distinguish the boundaries of membership, end quote. First Circuit doesn't know who's in and who's out. So the first group is out. Regarding people who have fled the gangs instead of continuing to pay extortion, the second proposed group, well, it's not socially distinct. Although Ms. Montoya-Lopez pointed to quite a few country condition reports and statistics showing how bad gang violence is in El Salvador and how the gangs target those who refuse to pay extortion, to the First Circuit, this quote focuses on her visibility to her alleged persecutors rather than the visibility of her alleged particular social group to society, end quote. And the latter is what the social distinction analysis requires. As we know, cat protection has no nexus requirement. It doesn't have to be on account of a particular social group, for example. But the First Circuit believed that Ms. Montoya-Lopez had waived the denial of cat by failing to meaningfully brief it before the first, and so the court denied the petition for review. And that is Montoya-Lopez v. Garland. To the Seventh Circuit we travel, with Munoz-Rivera v. Garland, published by the Seventh on August 24th, 2023. This case is about domestic violence, asylum, and credibility. Ms. Munoz was born in Honduras, but she moved to Guatemala at 25 years old to join her family there. She never received lawful status to live in Guatemala. And in Guatemala, quote, she entered into a 12-year relationship with a man named Eduardo, with whom she had two daughters, Ana and Maria, who by birth became citizens of Guatemala, end quote. Ana and Maria came with Ms. Munoz to the United States, and were derivatives on her eventual asylum claim. Eduardo began cheating on Ms. Munoz with a woman named Onieta when Ms. Munoz was pregnant with Maria. In her border interview, Ms. Munoz stated that she feared Onieta, who had threatened her and tried to get her to leave Guatemala. Quote, in response to a direct question about physical harm, Ms. Munoz stated that she had not been physically harmed by Onieta or anyone else. She also stated that the police would protect her in Guatemala. In an updated asylum application, however, she claimed that she was the victim of domestic violence at the hands of Eduardo, end quote. So it does look like an adverse credibility finding is probably coming. Quote, the declaration submitted with her application added that Onieta had threatened to kill her and also described an incident in which her husband chased her with an axe. In her legal brief in support of the application, she added that Eduardo repeatedly hit her and her daughters, end quote. Ms. Munoz similarly testified at her eventual merits hearing in immigration court. And remember, Ms. Munoz is a citizen of Honduras without legal status in Guatemala, but her daughters are Guatemalan citizens. Ms. Munoz feared that Onieta had family in Honduras that could find her and harm her in that country as well. Things got a bit complicated on cross and redirect during the merits hearing. Ms. Munoz seemed to be having some trouble differentiating between threats and physical violence, testifying that actually, Eduardo never harmed her, but then on redirect, explained that he had chased her with a knife every week for 10 years. She also testified, for the first time it appears, that Onieta had kidnapped Anna. Seems like more pre-hearing preparation for direct might have helped, but who knows? In any event, the IJ thought all of it didn't add up and issued an adverse credibility finding. The IJ denied all relief and protection, and the BIA affirmed. The Seventh Circuit affirmed that adverse credibility finding and the denial of all relief and protection. But not before giving some helpful quotes. Remember, that's what I do. For example, whether domestic violence qualifies a non-citizen for asylum is always a debate, and often comes down to the non-citizen meeting their burden to establish that the harm they suffered or feared was on account of one of the 5 protected grounds, the nexus issue. The Seventh Circuit states, though, without much qualification that, quote, victims of domestic violence may meet this burden if they would experience extraordinary abuse if they were sent back to their home country, end quote. Good quote. To be fair, in this case, the Seventh Circuit then immediately explained how Ms. Munoz hadn't shown that her proffered particular social group was cognizable, but hey, it's still a good quote. On credibility, which is really what the case is about, the Seventh Circuit held that Ms. Munoz had failed to adequately challenge the IJ's finding, summarily arguing instead, it appears at least, that the IJ was, quote, simply wrong, end quote. But that argument won't cut it. The Seventh Circuit deemed the credibility challenge waived, and then addressed it anyway. After the Real ID Act, purported inconsistencies need not go to the heart of an applicant's claim. An adverse credibility finding can still lie. But an IJ still, quote, must distinguish between inconsistencies that are material and those that are not, end quote. Satisfied here, though, whether Eduardo physically harmed her and whether her daughter was kidnapped, for example, are material, and the testimony was inconsistent on it, explained the court. Also, the standard to overturn an IJ on credibility is high, explained the Seventh Circuit, and here, quote, the immigration judge and then the BIA set forth in great detail the inconsistencies that it found most troubling, end quote. The evidence did not compel otherwise, especially where even redirect was kind of problematic for Ms. Munoz. Now, towards the very end of this decision, the Seventh Circuit notes that, actually, there was a, quote, police report describing the daughter's kidnapping and expert testimony, end quote. Okay then, that's definitely some corroborating evidence. And Ms. Munoz argued that the IJ failed to consider this clearly corroborating evidence in reaching the adverse credibility finding. But to the court, the IJ did consider it. But for example, found that the police report itself was problematic and, quote, unreliable due to the discrepancy about dates, end quote. Regarding the expert, well, explained the IJ, reasonably to the Seventh, the expert's testimony was largely based on what the expert had been told by Ms. Munoz, so factually, it all came down to her credibility, in large part. The Seventh Circuit believed that the IJ even, quote, acknowledged that the country condition reports corroborated problems with domestic violence. And the IJ was cognizant of the fact that victims of domestic abuse often have trouble testifying about it. But nevertheless, the IJ was unconvinced by Ms. Munoz's credibility, end quote. Love seeing that latter argument being made more and more, though, even though it didn't win the day here. Rejecting a few other arguments by Ms. Munoz, the Seventh Circuit affirmed, meaning Ms. Munoz is at risk of removal to Honduras, while her 2 minor daughters are at risk of removal to Guatemala. And that is Munoz-Rivera v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. Continuing on, we have Robbertse v. Garland, published by the 8th Circuit on August 21st, 2023. This case is about aggravated felonies. Miss Robbertse is from South Africa. I believe this might be a first on the podcast. She's lived in the United States for a long time and became a lawful permanent resident in 2012. Quote, she participated in an identity theft scheme with her mother that defrauded the California Employment Development Department of roughly $475,000 using the personally identifying information of over 50 people. In June 2019, pursuant to a plea agreement, she pled guilty to one count of aggravated identity theft predicated on wire fraud. End quote. Restitution was ordered by the criminal court, jointly with her mother, although not severally it seems, of over $475,000. Is it an aggravated felony? Specifically, an INA Section 101A43MI fraud or deceit offense involving loss to the victim or victims of over $10,000? If it is, Ms. Robbertse is removable. The IJ and the BIA found that it was, and denied all remaining claims for relief and protection. The 8th Circuit affirmed. In these type of cases, for this type of aggravated felony, to determine whether a state or federal criminal offense involves fraud or deceit, a court must apply the categorical approach. Here, as almost always, the wire fraud statute at issue is 18 U.S.C. Section 1343. And the reason we're focusing on that is because it's incorporated by reference into the aggravated identity theft statute that Ms. Robbertse was convicted of at 18 U.S.C. Section 1028A, C5. There are many other ways to commit that statute, but here the criminal court found that Ms. Robbertse did it through wire fraud. Summarily, the 8th Circuit determined that the underlying way to commit aggravated identity theft is an element rather than a means of committing the offense. And that means that yes, indeed, courts should focus on wire fraud identity theft rather than all the other different kinds of identity theft. The statute is divisible as to the underlying way of committing aggravated identity theft. And wire fraud, explained the 8th Circuit pretty quickly, always involves fraud. As an aside, isn't this the same aggravated identity theft just discussed by the Supreme Court in Dubin, episode 164? No discussion of how that case might affect the aggravated felony analysis. Interesting. Anyway, with the fraud stuff satisfied, the question became to the court, did the offense involve a loss to the victim or victims of over $10,000? The Supreme Court has permitted a circumstance-specific analysis rather than the strict categorical approach on this issue, meaning that courts can look to a lot of things to determine whether indeed the fraud portion of a conviction resulted in a loss of over $10,000. And remember, DHS has the burden to establish removability by clear and convincing evidence with an LPR like Ms. Robbertse. And thank you for recognizing 8th Circuit, quote, sentencing determinations, standing alone, may not always suffice. Such determinations generally rest on the preponderance of the evidence standard, end quote. That is, criminal sentencing documents don't apply the same heightened standard required for DHS to meet its burden on removability. So DHS might not be able to meet its burden by simply relying on sentencing documents ordering, say, restitution, because that underlying factual predicate is based on a preponderance of the evidence standard rather than clear and convincing finding. Plus, the loss must be tethered or tied to the fraud offense when, say, there is a multi-count conviction, explained the 8th Circuit. And the loss cannot be based on dismissed allegations, as is permitted at sentencing in lots of places. Really providing all the good arguments, 8th Circuit. But on the other hand, quote, express admissions, such as those found in a plea colloquy or written plea agreement, carry a general evidentiary value that may suffice, end quote. Plea colloquies almost always exist when there's a plea agreement. So be careful what you admit, criminal counsels. And then when a factual plea is viewed alongside those sentencing documents, well, non-citizens like Ms. Robbertse have a problem. Really can't stress enough how important it is for criminal counsels to consult with immigration counsels during plea negotiations, especially where the non-citizen is an LPR. In this case, Ms. Robbertse expressly consented to joint restitution well above $10,000. And she conceded her criminal activity aided her mother's fraudulent scheme as to a very large amount of money. This sufficed to the Eighth Circuit. Although the court didn't expressly mention that DHS actually met its burden, it held as much. Removability established, it looks like Ms. Robbertse applied for withholding of removal from South Africa. Can't apply for asylum because the conviction is a per se particularly serious crime because it's an aggravated felony. Ms. Robbertse wasn't sentenced to at least 5 years imprisonment though, so it's not a per se bar to withholding of removal. Rather, a multi-factor analysis from the decision matter of NAM is required for the particularly serious crime analysis for withholding in such cases. On that though, the Eighth Circuit held that the BIA and the IJ weren't so wrong in applying that multi-factor test, even though the crime wasn't a violent crime. To the court, it involved, for example, restitution of almost $500,000. Particularly serious. Not much analysis, though, in this case. Affirming the denial of cat protection as well, the Eighth Circuit ruled against Ms. Robbertse. And that is Robbertse v. Garland. Ending with quite the case on cat protection. This is Dang v. Garland, published by the Eighth Circuit on August 25th, 2023. Mr. Dang is from Sudan. Before there was more than one, but it looks like he's from the south. He was a child soldier in Sudan's brutal 40-year civil war. He was kidnapped at 8 years old and made to fight for the Northern Sudanese army. Quote, "For a year, Mr. Dang was forced to travel to other villages with the child soldiers, kidnapping children and killing or maiming anyone who interfered." End quote. He escaped at 9 years old. He eventually made it to Egypt where his family had fled to, and he lived with them for a few years in Egypt until 2003. The whole family came to the United States as refugees later that year, but Mr. Dang never adjusted his status to lawful permanent resident status. Perhaps unsurprisingly, Mr. Dang, quote, has serious mental health issues arising from his horrific childhood, end quote, including depression, anxiety, paranoia, nightmares, panic attacks, and PTSD. And then at some point in the U.S., Mr. Dang got convicted of attempted murder. The Eighth Circuit doesn't go into the facts, but ultimately it came to removal proceedings, where an immigration judge determined that the conviction barred Mr. Dang from everything except Convention Against Torture, deferral. The IJ and the BIA denied it. Notwithstanding that South Sudan is now in its own civil war type conflict that now seems to continue on year to year to varying degrees of intensity. Quote, "The IJ believed the South Sudan government would understand Mr. Dang was kidnapped by the Northern Army and forced to be a child soldier many years ago during a period of civil war," end quote, and so reasoned the IJ wouldn't torture or punish him for what he did. Nor did the IJ or BIA believe that Mr. Dang would be tortured because of his mental health issues if returned to South Sudan. The Eighth Circuit affirmed denial of cat protection. To the court, Mr. Dang, quote, left South Sudan 24 years ago and has no contacts with anyone there. He admits he knows no former child soldiers who have had problems with the South Sudan government in recent years. His proffered evidence that the South Sudan government looked for him in the past is dated, vague, and highly ambiguous, end quote. As to his mental health-based fears, the Eighth Circuit agreed with the BIA that the hypothetical chain of events Mr. Dang proffered were not likely enough each to occur. He hadn't shown that he'd have a PTSD event, not receive treatment, be imprisoned for something he did or didn't do because of it, and then that he'd be tortured in a Sudanese prison. The matter of JFF argument. He hadn't shown that each hypothetical link in the chain is more likely than not to occur. Seems though that in South Sudan, there is, quote, country conditions evidence that persons with mental disabilities are often held in prison and may remain in detention without treatment for undetermined periods, end quote. Still not specific or particularized enough for the court in this case. Maybe an expert would have helped. Particularly because the Eighth Circuit also didn't see evidence sufficient to show that torture occurred in South Sudanese prisons of people like Mr. Dang. quote, abusive or squalid conditions that result from a lack of resources rather than a specific intent to cause severe pain or suffering do not establish torture under the CAT, end quote. Mr. Dang therefore lost his case, in no small part because his serious criminal conviction narrowed what he could apply for in immigration court. I wonder whether ICE can remove him, though. After all, I doubt he's a citizen of South Sudan, right? Because he's never actually lived in that country. Because it didn't exist yet when he left. Quite the issue. Before we conclude the week, the matter of JFF argument, requiring a showing that each hypothetical link in the CAT claim is more likely than not to occur, is good law in the Eighth Circuit, according to the panel. But it doesn't appear to be good law in the Fourth Circuit, as recently discussed on episode 168 in Santos Garcia v. Garland. Check that out. Maybe argue to extend it in other courts? And that is Dang v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.